Whether you're buying or selling your home, get the benefit of expertise.
Hey, well, compliments to the show. You're really hitting on the subjects and you're telling the truth. I appreciate you.
Meet the team at dangemus.com. And now, filling in for Dan Gemus, your host, Joyce Blackmere.
Welcome back, everyone. Thanks for tuning in today. I'm Joyce Blackmere, Director of Sales with the Dan Gemus Real Estate Team. And with me in studio, I have Heather Marentet, Sales Rep with the team. Hello, Heather.
Hi.
We also have Christian Janisse, lawyer, owner from Simplyclose Law in Amherstburg. Hi, Christian. How are you?
Hey, how are you both doing?
Good,
Great.
good. What have you got for us today?
So I had an interesting situation that happened, and this would probably apply more to the realtors that listen. I had somebody, they weren't a client, but somebody who called the office. They had a situation where they had an offer that was put out. Then the seller did a counter, and it was irrevocable until 6 p.m. And the buyer, who submitted the original offer, signed it at 4:59 p.m., but it was irrevocable until 6. But the realtor was busy, so they didn't communicate that acceptance until 10 p.m. that night. And so the dispute was over. Was it accepted at 4:59 p.m. and it's binding, or was the fact that it wasn't communicated to the other side by 6 p.m. when it was, that's when the irrevocable deadline kicked in? So they weren't told. So was the seller able to back out of that deal even though their counteroffer was accepted before they were told about it? And so just thinking logically, I was like, well, that makes sense. They signed it at the right time. The realtor could have been busy. Maybe they had like a kid's hockey game or something. Are they supposed to just sit around and wait? Well, I did some research, and even though it's kind of intuitive to think, well, yeah, they signed it and they sent it back the same day. Like, it's not like it was 48 hours later. It was the same day. But the case law says that you have to communicate your acceptance within the irrevocable period. Now, I was kind of shocked to learn that. Like, it kind of went against what I would have thought would have been the case.
Yeah, that's really interesting. It does say that, though, in the agreement in a way, right? I don't know the exact terms, of course, because I don't have it in front of me.
That notice has to be provided? Is that what it is?
So it does, but it says that it has to be signed by the irrevocable time. But then where I got confused, because when I first read the agreement, I was like, yeah, it was signed before the irrevocable time. But when you go and look at the case law, and maybe it's just because I'm so far removed from law school, thankfully, case law 101 is that you have to communicate your acceptance. So you can't just accept it, you also have to notify the person that it's been accepted. And this was a bigger issue back in the day. It's not so much now because email and text messages are instantaneous. But back in the day, you used to mail something and then you'd mail it back, and they'd say, well, you mailed it back, but we didn't receive it on time. And then there was this whole post office, post box rule, and we'll get into that. But they had all these rules because back in the day it wasn't as easy to have instantaneous communication. So it was like, we mailed it back to you, but we also left you a voicemail, but the voicemail was received afterwards. So that's where all the case law goes to, is does it have to be communicated? And in today's day and age, it is instantaneous, so you could communicate it right away.
Right. So that communication is acceptable by email, text message, call,
good old-fashioned phone call.
Anything like that?
Yeah, it could have been a voicemail. You just have to indicate that it's been accepted. You don't necessarily have to send the agreement right away. Like, let's say you have a client that was hand signing, you had to scan it or something, because some people still sign with wet ink, right? Yeah. In that case, you don't necessarily have to scan it and send it over, but you do have to communicate that it's been accepted and the paperwork is on its way, which I was totally shocked to see that because it was signed before the irrevocable time. So could the seller back out? And it was, obviously there's a debate. There's definitely a debate that could happen here, but it wasn't as black and white as I would have liked it to have been.
Well, I would say, so if you don't communicate it and the irrevocable time has passed, that seller then thinks that their house is available again. So then they could, in theory, if it hasn't been communicated, potentially accept another offer, right?
And that's
so
exactly
if you're not
what
communicating it, that's when you could run into issues.
Yeah, and that's exactly what happened here, was that they got another offer for more money, and they wanted to use the fact that their counteroffer was not accepted on time, and that they want to take the second offer.
Yeah, so I mean, there would be grounds for arguing it, at least, for sure.
Yeah, it's just crazy because it wasn't, I could see that if it was just thinking like, okay, in society, like, do we actually have to send things right away? It was sent 4 hours after the irrevocable period. So if you have children or if something's happening, like, you might not get it. So it's like, okay, I sent it to you through DocuSign or AuthentiSign. It's not like as the realtor you have to sit there and wait at your computer. I didn't imagine. And they signed, and then you go check your emails later when you're done dealing with it. Oh yeah, great, they signed, and now I'm going to send it over. So I was like, yeah, it's black and white. They signed it before. It was communicated within a timely manner. I mean, if they held out for a day or 2 days, and it's like, well, yeah, you can't just sit on it forever and say, oh yeah, never mind. Here, a week later, I forgot to tell you I signed it. But it wasn't as black and white as I thought, and I was a little shocked to hear.
So the sellers went ahead and accepted the second offer that came in at the higher price?
Well, I told them that it's not black and white, now it's with them to figure out what they want to do. Because I think that there's still an argument that, because it does say that it has to be signed. It doesn't say that it has to be communicated within that time. But the case law, which has nothing to do with the standard ORIA form, just case law contract 101, says that acceptance has to be communicated. So now it's like, great, we're in a gray zone, which, as you know, dealing with contracts on a regular basis, there's always a gray zone, and it sucks.
Yeah, no, 100%. That can make it stressful for everybody. And I mean, if the buyers with the first offer lost out, that's a shame.
Time is of the essence.
It is.
Says,
yeah,
right?
that's right. That's right.
So now it's
literally,
like,
it's a very literal term.
Yep.
Yeah, and I thought, like, okay, I'm going to follow the literal terms of the contract. It says that it has to be signed. Or no, it says it has to be accepted. That's the word language, is that it has to be accepted by 6 p.m. or whatever, right? And I thought, okay, well, accepted means to sign it. Like, accepted doesn't mean I've communicated it. That was my logic, just without doing any research, was it was accepted. It was accepted when it was signed. And then the communication of the acceptance followed within a timely manner right afterwards. But come to find out, case law 101 is that acceptance, like communication of acceptance, has to be before the irrevocable period. I mean, I think there's a debate to be had here, because who knows, like, is it really that black and white? I don't know. You'd have to go in front of a judge, and then oftentimes it's not really worth it. But I was hoping we'd have like a clear cut, okay, it was accepted, why are we fighting over this? Here's the rules. But as I did research, obviously I've learned a lot. I learned a new thing.
Yeah. Well, I mean, hey, that's always positive too. It's always good to learn other things, but it's also good for buyers and sellers out there, not just the agents, to hear this, because they'd also need to know that time is of the essence, and it's really important to follow them because it's a competitive market, and you risk losing out to another buyer.
Yeah, and if you're cutting it close to those irrevocable times, just making sure that you are available as an agent, let's say, to make sure that once that is received, it is communicated promptly, so you're not running into any of these issues. Yeah,
and even just beyond that, like irrevocable clause and things like that, it just goes to show you that even if you think one thing and I mean, this is just law in general, but if you think something, sometimes you're like, yeah, this makes total sense. Then you go do research on it, and you find out that 5 judges have not done something that you would think makes sense. And then you're like, oh, wow. So like those contracts are just, they're so finicky and they're so tricky sometimes over the smallest little things. And even this is like a situation where I'm like, come on, who would even argue over this? But you've probably seen it many times where, well, another offer comes in out of nowhere, and now all of a sudden this thing that you never thought would happen, that would never be an issue, is all of a sudden an issue.
Oh, yes. The past couple of years, with all the changes in legislation and what have you, all of these things will never happen scenarios are coming up. So we're learning lots, and it's awesome. And, we appreciate having you in our office because you're very accessible to us and to our clients. And we appreciate that very much because we often have questions. There's often gray zones that present themselves, and we need that extra guidance, and or our clients need that extra guidance or validation to help them make decisions, which is awesome. So thank you for being there for us.
Selfishly, it helps us when we work on the deal afterwards. It's so much easier if everything was done, like if all parties are on the same page beforehand and making sure that what was meant to be communicated is communicated that way. Because whenever you have to deal with issues afterwards, it's not pleasant. And it's not pleasant for the realtor either. It's not pleasant for the parties involved. Like, to have to communicate, what we thought was going to happen is not going to happen, and I like real estate because for the most part it's not that argumentative. I know everybody thinks lawyers like to argue. I like it because it's usually pretty pleasant. You hand the keys to somebody, they're excited, or we do electronic deposits, but you give them the money and they're excited.
Yeah.
That's the part that I'm most interested in.
Awesome. Well, Christian, thanks so much. If anybody has questions for you, they're looking for for a real estate lawyer, how can they get a hold of you?
They can call us at 519-997-3775, or they can email us at hello@simplyclose.ca.
Awesome. Well, thank you. Thank you so much again. Appreciate you. We need to go to another break. And when we come back, we're going to talk about a few questions that you should consider asking your moving company before you go ahead and hire them. There's still more to come, right? Oh, actually, no, sorry. Before we go to break, we're also giving away a gift card to the Richmond Popcorn Company. Caller number 6, 519-792-2559. Caller number 6 will be eligible for a gift card to the Richmond Popcorn Company. Still more to come here on the Dan Gemus Real Estate Show.